You're facing criminal charges after a fight, and you're not even sure if you're the one who broke the law. Maybe it was self-defense. Maybe you were trying to protect someone else. But now you're being treated like the aggressor. And in Oklahoma, if you don't respond strategically, you could be looking at jail time, a permanent record, or worse. I'm John Cannon, criminal defense attorney here in Oklahoma, and I'm going to walk you through exactly how to challenge those charges and when you can get them dismissed entirely, so you can defend yourself the right way, avoid a conviction, and move on with your life without this hanging over you. And stay with me to the end, because the biggest mistake people make in self-defense cases is not what happens during the fight, it's what they do right after, when adrenaline is high and they think they're clearing things up. All right, let's get into it. If you've been charged with assault in Oklahoma, but you believe you are defending yourself, your mind is probably spinning. Will anyone believe me? How do I prove it was self-defense? Can these charges actually get dismissed? Here's the reality. The police make quick decisions at the scene, and those decisions are often based on limited information. Then the prosecutor files charges based on what they get in those reports, the statements, the photos, and whatever evidence exists at the time. And if it goes far enough, a judge or a jury is the one who ultimately decides whether what you did was unlawful or justified. So your job is not to argue on Facebook or try to convince the officer on the sidewalk. Your job is to build a self-defense case the right way, with the right evidence, and do it early. Now, let's start with the basics, because that is where people get tripped up all the time. Self-defense in Oklahoma comes down to a few common sense ideas, but the details matter. In plain English, self-defense means you use force because you honestly believed you were in immediate danger of being harmed. But the law also asks a second question. Would a reasonable person in your position have believed the same thing that you did? So it's not just, I was scared, it's, I had a real reason to be scared. Now, here's the line that makes or breaks most cases. You're forced to be reasonable in the moment. If someone shoves you, you generally can't respond with something wildly more dangerous, like shooting them. If someone is yelling in your face, that does not automatically justify you throwing the first punch. And one more key point, you usually cannot be the initial aggressor. If you started it or you escalated it, self-defense gets harder and harder to prove. Now, Oklahoma is a no duty to retreat state in many situations, meaning you don't have to automatically run away if you're somewhere you have a right to be and you are not the aggressor. But no duty to retreat is not a free pass to fight everyone. It's protection for people who are genuinely defending themselves. Bottom line, self-defense is real in Oklahoma, but it's judged by reasonableness, necessity, and whether you were the one who caused the situation in the first place. Now, here's the next question. Even if you know you acted in self-defense, how do you prove it? That's the whole game. Now, here's the next question. Even if you know you acted in self-defense, how do you prove it? That's where strategy meets reality. Police and prosecutors don't live inside your head. They live inside evidence. So if you want self-defense to work, you have to build proof that tells that story clearly. Here's what we look at in most every self-defense case. First, injuries. Did you have marks on you? Bruising, scratches, swelling, any medical treatment? Photos taken early matter. Medical records matter. Second, witnesses. Who saw the start of it? Not just the middle, but the start. Most cases get distorted because people only see the last 10 seconds or remember only certain parts in the moment. So we want names, numbers, and statements from people who saw the threat happening first. Third, video. This is huge. Doorbell cameras, bar cameras, store cameras, people's cell phones, parking lot cameras. Video doesn't have opinions. It shows timing, distance, who moved first, and whether the threat ended before the force was used. Fourth, messages and history. Sometimes there are texts, voicemails, or prior threats that show why you had a real reason to fear harm in that moment. And yes, your statement matters too, but this is where people blow it because they think talking will help in the moment, and often it does the opposite. So let's talk about what you should do right now if you've been charged, not later, right now. If you're watching this because you were just charged after a fight, here are the moves that protect you in your future. Number one, don't talk about the incident publicly. No social media, no I had to do it, no vague posts, no memes, nothing. Number two, don't text the other person about what happened. Not an apology, not an explanation, not are we good? Not tell them you started it. Those messages become evidence and they rarely help you the way you think they will. Number three, write down everything while it's fresh. Where were you standing? Who was there? What was said? Who touched who first? Do it for your lawyer, not for the internet. Number 4, list witnesses and location of cameras if you know them. Most video gets overwritten or deleted in a number of days, sometimes weeks. If you don't move early, the best evidence disappears. You need to have your attorney do a preservation letter and seek to recover those videos. Number 5, preserve physical evidence. Clothing with tears, blood, dirt, anything that shows what happened. Don't wash it, don't toss it. And number 6, talk to an Oklahoma criminal defense lawyer early, because self-defense cases are won by speed and details. Now, let's talk about the state's burden, because this is where people finally start to feel hope. The prosecutor still has a job to do. For assault type charges, the state usually has to prove that you intentionally acted unlawfully, and self-defense changes the whole conversation. Because if your force was justified, it's not a crime. So what does the prosecution try to do? They try to paint you as the aggressor. They look for anything that suggests you wanted the fight. They look for anything that suggests you kept going after the threat had ended. They look for anything that suggests your response was out of proportion for the situation. This is why the timeline matters so much. Who moved first? Who escalated? Whether the threat stopped? Whether you stopped? And this is why your own words matter so much. Because if the state can quote you as angry, boastful, or admitting you lost it, they'll use that to argue your intent. Which brings us to the big question everyone asks. Can these charges actually get dismissed? Yes, sometimes, but it depends on how you and your attorney approach the case. There are a few common ways self-defense cases end without a conviction. 1, the prosecutor dismisses the case before trial. This happens when your lawyer brings real evidence early, like video, witness statements, or proof the other person was the aggressor. 2, the judge dismisses it at a pretrial stage if the case is legally weak or the evidence can't support the charge. 3, you win at trial. If the jury believes that there's reasonable doubt and that you acted in self-defense, you can get a not guilty verdict. 4, deferred outcomes. Sometimes if the facts are messy, but you have no record, there may be options that keep a conviction off your record if you complete conditions on probation. 5, a negotiated reduction. Not every case is a drop it or nothing. Sometimes the right move is reducing it to something that avoids the worst long-term damage or potential consequences at trial. Every case is different, but here's what doesn't change. Dismissals happen when you bring receipts, not emotions. Now, let me give you a real-world scenario so you can see what this looks like when it works. Here's a situation I've seen in Oklahoma more than once. Someone is out at a Norman spot. A stranger is intoxicated. Things get tense. The stranger threatens, steps in, maybe shoves first. Our client pushes back hard. The other guy falls. Now the police show up and someone points at my client and says, he did it. On paper, it looks bad. But then we pull the video from the bar. We talk to witnesses who saw it first. We show that the force was quick, direct, and ended when the threat had ended. We bring that to the prosecution early. And when the evidence is clear, those cases get dismissed. Not because someone got lucky, but because the defense did the work and did it fast. And prosecutors want to do the right thing if you show them the evidence. Now, there's one more piece you need to understand because it comes up constantly. Stand your ground and castle doctrine. Oklahoma truly believes in self-defense protections, especially when you're somewhere you had a right to be and you're not the aggressor. And there are additional protections when you're in your home and in certain situations involving your vehicle or at your business. Here's the important thought. These laws don't protect someone who starts the confrontation and then tries to label it self-defense. They protect people responding to a real threat. So if your case involves a fight at your home, your property, your workplace, or around a vehicle situation, it becomes even more important to get the facts right and build the legal argument the right way, because the details decide whether those protections apply to you. Now, let's wrap this up in a clean action plan. What to do next? If you're facing assault charges in Oklahoma and you believe it's self-defense, don't panic, but don't drift either. Self-defense works when your fear is reasonable, your response is reasonable, you weren't the aggressor, and the evidence supports your timeline. So if you're facing assault charges in Oklahoma, do these things right now. Stop talking about it publicly. Stop messaging people about it. Write down your version while it's fresh in your memory. And if you have a loved one in jail, make sure they're not talking about it on the jail phone because those are recorded. Also, preserve evidence and identify cameras if you can. And most importantly, get an experienced Oklahoma criminal defense lawyer involved early. because the best self-defense cases don't get won in the heat of the moment. They are won afterwards by building the story the state can't disprove. And here's the mistake I promised at the beginning. People try to smooth it over after the fight. They apologize in text, they explain, they negotiate, they post, they vent. It's human nature, but they create evidence. So keep your case off the phone. Now, if this video helped, you need to watch the next one, how to beat a destruction of property case. Because a lot of fight cases come with property damage allegations too. And those charges have their own traps that people don't see coming. Click that video next, and I'll see you over there.